Okay, if there's one thing that destroys law students in exams, it it is not always a lack of knowledge or a lack of time. Students actually know the work, but they don't know how to structure legal answers properly. And trust me, as somebody who has worked as a marker for almost 2 years during law school, I can immediately tell the difference between a student who understands legal structure and a student who is panic writing emotionally. One student writes with direction, logic, and confidence, while another student writes everything they memorized, hoping that somewhere inside the chaos there will be marks. That is why in today's video, I want us to break down FIRAC. We break it down properly and practically using one of the most interesting concepts in private law. This is a first year case from the law of persons, the Nascaturas fiction, right? We are not doing this in a robotic textbook way. We are doing this in a way that actually helps you survive problem questions in law school, right? So, hello guys. My name is Tabang. I recently completed my LLB and I'm currently doing my LLM in environmental law at the University of Cape Town. And throughout law school, one thing I realized is very quickly is that legal writing is a skill. Law school is not simply about memorizing notes and repeating them in an exam. Lecturers are testing whether you can identify legal problems, explain legal principles, and apply those principles logically to the facts, right? So that is why two students can study the same notes but walk away with completely different marks, right? One student understands the structure and legal reasoning, while the other student is just repeating information. And honestly, once you understand FIRAC properly, problem questions become far less scary because your brain finally has a system to follow. And also, guys, before we continue, if you really want like deeper law school support, definitely check out the membership section on the channel. For members, I'm planning to upload detailed members only videos. Some of them are already there, full problem question workshops, assignment guidance, exam strategy sessions, and even one-on-one consultations. Because honestly, sometimes students don't just need notes. They need direction, they need structure, and sometimes they need somebody to explain things practically. So memberships also help to support the channel directly and allow me to continue making more educational content consistently. So if you want access to deeper breakdowns and actual law school survival tactics, definitely consider joining. Now, let's start with the actual legal concept, right? We are using the nascaturas fiction. So that term nascaturas it's a Latin word referring to an unborn child. The nascaturas fiction is a legal principle where the law treats an unborn child as if it has already been born, but only where this benefits the child and provided that the child is eventually born alive, right? In other words, the child is not yet a full legal person in the ordinary sense, but the law creates a legal fiction in order to protect the interest of that unborn child. And honestly, this is one of those concepts that makes law very interesting because you start seeing how the courts used fairness and legal reasoning to protect vulnerable interests even before birth. Right. So traditionally, the nascaturas fiction was mainly associated with inheritance, like with the law of succession, right? So the classic case student often learn first is the ex parte Budal-Steenkamp. In simple terms, the court recognized that an unborn child could inherit benefits if that child was later born alive. So originally, the fiction existed mostly within the context of succession and inheritance. But then South African law started evolving beyond inheritance, and the courts began asking a much deeper question: can this fiction also be applied in dealing to an unborn child suffers injuries before birth, right? And this is where one of the most developments in South African law takes place. Before the case of the Road Accident Fund versus Mtati, there was another important case called Pinchin versus Santam Insurance. This case was It was significant because it helped extend the Nasca-Choras fiction into the law of delict. So the court recognized the possibility that a child born alive could claim damages for injuries suffered while still in the womb, right? So that was a major legal development because now the fiction was no longer limited to inheritance, to law of succession. It started becoming relevant in personal injury and damages claims as well. And honestly, guys, this is why understanding the development of legal principles matter in law school, because the law is not static. Courts constantly develop and adapt principles in order to achieve fairness and justice in the changing circumstances, right? Okay, so now let's go back to our FIRAC. So let's use FIRAC properly. Now let's use FIRAC properly. Imagine a scenario. Ayanda is 8 months pregnant, right? And then she's involved in a car accident that is caused by a reckless driver. And then the unborn child suffers serious injuries while still in the womb, right? And later the child is born alive with permanent medical complications. So the legal question now becomes whether the child may claim damages for injuries suffered before birth. And this is where FIRAC helps us to structure our thinking instead of panicking, right? The first part of FIRAC is the F, right? So the F stands for facts. One of the biggest mistakes that students make in problem question is including unnecessary information. Guys, not every fact matters equally in law school. Markers are looking for legally relevant facts, not storytelling. So in this scenario, the most important facts are that Ayanda was pregnant. One, there was a motor vehicle accident, and the driver acted negligently. The unborn child suffered injuries in the womb, right? And the child was later born alive. So basically, those are the legally relevant facts. We don't care about the color of the car or the song that was playing in the background. We focus on the facts that matter legally, right? So now, as somebody who marks scripts, and I'm going to keep saying this, you're going to get tired of this. As somebody who marks scripts before, students often they often lose focus because they rewrite the entire story instead of identifying what actually matters, right? So now, in the second part of FIRAC, that is your I, the issue, right? This is where you identify the legal question the court must answer. Honestly, if you identify the issue badly, your entire answer starts collapsing because now your discussion lacks direction. So in this scenario, the issue would be framed as follows, right? Can an unborn child claim damages in delict for injuries suffered while still in utero or while still in the womb, right? Notice how the issue is phrased as a legal question, right? Markers love that because it immediately shows that you understand what our legal problem must be resolved, right? Then now we move to the third part of FARAC, which is R, the rule. This is where you explain the relevant legal principles and authorities. So here you would explain the Nasca-Choras fiction and define it properly. You would explain that the law treats an unborn child as if they're already born whenever this is to the benefit of the child, provided that the child is eventually born alive, right? You would then support your discussion using authority. You would mention the ex parte Buddha Steenkamp for traditional inheritance position. Then explain that how Pynchon versus Santam Insurance extended the principle into delict. And finally, refer to the road accident fund versus Mtat, where the court recognized that an unborn child would claim damages for prenatal injuries suffered while still in the womb, right? And this is where you show the examiner that you know the law properly. But guys, please don't emotionally dump every case you remember into your answer. Markers are not counting how many cases you know. They are looking at whether you understand how to use those authorities properly and relevant, right? Now we arrive at the most important part of FIRAC, which is the application, which is your A in the FIRAC, right? And now, trust me, as somebody who has marked scripts before, and I'm saying this again and again and again, this is where students separate themselves, right? Many students know definitions and legal principles, but they struggle to apply the law directly to the facts. And honestly, application is usually where most of the marks are found. So here you would connect the legal principles directly to the facts of the scenario. You would explain that in the case, right? So the unborn child suffered injuries while still in the home due to the negligent conduct of the driver. Although the child had not yet been born at the time of the accident, the child was later born alive. Therefore, the Nesca restriction may apply in order to allow the child to claim damages for prenatal injuries, right? That is the application. You are taking the law and directly connecting it to your scenario, right? And honestly, this is where students either cook or collapse in the law exams, right? Honestly, this application section alone is where many students lose massive marks. That is why for channel members, I'm planning to do like a full members only workshop where we actually answer problem questions together step by step, not motivational speeches or actual exam survival tactics, because sometimes students understand theory but still struggle with application, and that is exactly where guided practice becomes important. Now, the final part of FIRAC is the C, which is the conclusion. Please, guys, please, 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 I am begging you, right? Don't stop randomly because your brain disconnected from the Wi-Fi halfway through the paragraph. Your conclusion should answer the legal issue clearly and logically. So in this scenario, your conclusion could look like this, right? Your conclusion could be that the child would likely succeed in claiming damages through the application of the Nesca fiction. A proper conclusion ties your entire answer uh, together, and it shows the examiner that you have completed your legal reasoning properly, right? Now, let me save you some pain by discussing the biggest mistakes students make in FIRAC questions. The first mistake is defining only. Definitions alone don't get high marks. They are important, yes, but they don't give you high marks. The second mistake is explaining the law beautifully without applying it to the facts. And trust me, markers notice that immediately. The third mistake is panic writing, right? And dumping every case remembered into the answer, and when it is irrelevant. So please stop emotionally attacking the examiner with random notes. Be relevant, structured, and logical. And another major mistake is failing to conclude properly. Even if you are unsure, conclude logically based on the information that is available. And honestly, guys, FARAC is not there to make your life harder. It is there to stop you from panicking. Once your brain has a structure, problem questions stop feeling impossible. And trust me, sometimes the difference between a 50 and a 70 is not intelligence. It is a structure, it is technique, it is application. And again, guys, if you want more personalized support, assignment guidance, members on the breakdowns, one-on-one consultations, and deeper law school support, definitely consider joining the membership. The public videos are great, but the members only content is where we really start cooking properly. And honestly, memberships also help me continue making more educational content. If this video helped you, make sure that you subscribe, because next we are talking about how to read cases faster, how to answer problem questions properly, and generally how to survive law school without losing your mind. And trust me, we are surviving this degree together. Together, sisonke.